I was talking to a friend of mine the other day. He's got a young son. My son just turned 19, and I was telling him about how child support is not really for the kids. It's not really for any families. It's not for the people. And just he said that just sounds like conspiracy theory. He knows I've been studying law. He knows that I took classes to start understanding and learning law. But even then, and after a few years of actually finally getting a hang of this stuff, he still did not believe me. And that's fine because nobody should believe me unless they go look it up. So, this is a Supreme Court case from the United States. Okay. I got this off courtlistener.com, and I just basically transferred it over here to WordPad so I could highlight some of the things that I just want to read. I don't want to read the whole case, but this case is going to explain to you exactly what child support is. Okay, so this is Blessing versus Freestone, and this is volume 520 under the United States, page 327. And this happened in 1997. Now, when I read these, I'm not going to go ahead. I'm not going to go and read and cite all that law. You can read these. When you go into Court Listener, a lot of these will be highlighted, so you can click on certain things that they say in here and go into a different case. But I kind of want to try to make this a quicker video. So, this case concerns a lawsuit brought by 5 mothers in Arizona whose children are eligible to receive child support services from the state pursuant to Title 4D of the Social Security Act. And these custodial parents sued the director of Arizona's child support agency. Okay. Arizona participates in the Federal Aid to Families with Dependent Children, or AFDC program, which provides subsistence welfare benefits to needy families. To qualify for federal AFDC funds, the state must certify that it will operate a child support enforcement program that conforms with the numerous requirements set forth in Title 4D of the Social Security Act. AFDC recipients must assign their child support rights to the state and fully cooperate with the state's efforts to establish paternity and obtain support payments. You want to know what that means, ladies? You are an AFDC recipient, and you are assigning your child support rights to the state. That's what the Supreme Court just said that. I didn't say that. Although the state may keep most of the support payments that it collects on behalf of AFDC families, I'm going to read that part again. Although the state may keep most of the support payments that it collects on behalf of AFDC families in order to offset the costs of providing welfare benefits, until recently it only had to distribute the first $50 of each payment to the family. You could get, child support $400 a month, and at that point, they only had to send out the first $50. Yeah, that's great. The structure of each state's Title 4D agency, like the services it provides, must conform to federal guidelines. If a state delegates its disbursement function to local governments, it must reward the most efficient local agencies with a share of federal incentive payments. So the more these agencies come in here and pretend that you need to be on child support and don't tell you the contract because you don't know how to fight a contract, and even if you did, 1 out of 10,000 might do it, so they're still making a bunch of money. You see where this is going, people? Okay. To oversee this complex federal state enterprise, Congress created the Office of Child Support Enforcement, or OCSE, within the Department of Health and Human Services, or HHS. If a state does not substantially comply with the requirements of Title 4D, the Secretary is authorized to penalize the state by reducing its AFDC grant by up to 5%. Arizona failed to collect enough child support payments and federal incentives to cover the administrative costs of its Title 4D program, one of only 10 states to fall below that target. So the respondents are 5 Arizona mothers, some of whom which receive AFDC benefits, whose children are eligible for Title 4D child support services. Respondents sought to represent a class of all children and custodial parents residing in Arizona who are or will be entitled to Title 4D services. Respondents claimed that the state's systemic failures violated their federal rights under Title 4D, invoking Title 42 of the United States Code, Statute 1983, which will be explained in just a moment. They asked the district court to grant them the following broad relief. You can go and read the relief. The director immediately moved to dismiss the complaint on several grounds, arguing primarily that Title 4D creates no individual rights enforceable under 1983. The Court of Appeals also disagreed with the district court's conclusion that Congress had implicitly foreclosed an individual remedy under Statute 1983 for violations of Title 4D. The majority noted that Title 4D includes no provisions for judicial enforcement that might supplement the Statute 1983 remedy. The Supreme Court says, we granted certiorari to resolve disagreement among the courts of appeals as to whether individuals may sue state officials under Statute 1983 for violations of Title 4D. This is where it gets good, people. This is what the Supreme Court says of the United States. Section 1983 imposes liability on anyone who, under color of state law, deprives a person of any rights, privileges, or immunities secured by the Constitution and laws. In order to seek redress through Statute 1983, however, a plaintiff must assert the violation of a federal right, not merely a violation of federal law. We have traditionally looked at 3 factors when determining whether a particular statutory provision gives rise to a federal right. First, Congress must have intended that the provision in question benefit the plaintiff. Second, the plaintiff must demonstrate that the right assertedly protected by statute is not so vague and amorphous that its enforcement would strain judicial competence. Third, the statute must unambiguously impose a binding obligation on the states. In other words, the provision giving rise to the asserted right must be couched in mandatory rather than precatory terms. In their complaint, respondents argued that federal law granted them individual rights to all mandated services delivered in substantial compliance with Title 4D and its implementing regulations, without distinguishing among the numerous rights that might have been created by this federally funded welfare program. The Court of Appeals agreed in sweeping terms that Title 4D creates enforceable rights in families in need of Title 4D services. That's what the Court of Appeals thought. The Court of Appeals did not specify exactly which rights it was purporting to recognize, but it apparently believed that federal law gave respondents the right to have the state substantially comply with Title 4D in all respects. The Supreme Court disagrees. This is it right here, people. The Court of Appeals did not engage in such methodical inquiry. As best as we can tell, the Court of Appeals seemed to think that respondents had a right to require the director of Arizona's Child Support Agency to bring the state's program into substantial compliance with Title 4D. But the requirement that a state operates its child support program in substantial compliance with Title 4D was not intended to benefit individual children and custodial parents, and therefore it does not constitute a federal right. It's not a law. You can't. This is the Supreme Court. Look it up for yourself. This is what it is right now. It wasn't intended for your children. It wasn't intended for the mother, the father, none of it. What it is, the primary goal is to raise grant money for the states. So when you get a bunch of people in authority that are totally confused and ignorant to the laws anyway, and they're put into their positions, and they start coming and after you for putting you on child support and all this stuff. You don't even know how you got into the contract. You don't even see. This is it's bad because to me it's extortion in the way that at least in my case and a lot of other people that I have talked to, it's almost like you go in there and if you go in there, my case was a little different. I'm going to go into that in a different video, but that it's almost as if you're getting forced or prepared to do this child support thing, and they're not even telling you that it's voluntary. They don't tell you that. They want you on the program, and as long as you have a social security number, you can get on the program. Okay? Well, up to a certain extent, actually. If you're a non-citizen who comes here for a work visa and you get a social security number, I don't think that they can actually put you fully on the program because it's supposed to be for what they would call citizens. But I have had stories where a guy out of Africa, he came here and filed for a work visa, and they gave him an application for a social security number. While he was here, he had a girlfriend, got her pregnant, and then she wanted to file for child support. And what had happened, he told me, he said that they couldn't. That the judge, who I'm pretty sure was not a judge, I'm fairly certain it started through the executive branch, and there's another video that explains that, but said that he cannot be put on a regular child support, but they did make him make one payment. And when he told me that, I realized that what they're doing is they will, in some circumstances, at least one, talking to this guy, that they got him to at least be on the books, but they legally really couldn't get him to have reoccurring payments in this program because he wasn't a citizen. Okay, so they're shiesty apparently. I mean, these people, for whatever reason, some of these people are trying to. They think it's a game. It's not their kids. It's not their people, and they don't. They are hurting people by making people believe that this is mandatory, that you have to do this. And child support has nothing to do with supporting children, just so you know. That's absolutely right. And so once you get into law and you start studying it, you're going to understand that words are very particular. Okay? So you'll hear these, you'll watch these videos, and they'll say, don't be an obligor, be a man. Well, they don't even know what an obligor is. If you look up in the law what an obligor is, that if you enter into any contract, you're an obligor. If you bought a house, you're an obligor. If you're, if you're whatever it is, okay, you're obligated because you have decided to participate in a contract. That's 100% what it is. Okay, so basically, being able to use these like this, what I've got highlighted here, in your cases, this is the kind of stuff you want to put in your motions. Okay, um, and there's ways to do motions. You have to get your state. You have to look at your state rules, because most of the time you're going to be starting in your state, or you get your federal rules, and it tells you how to do the procedures, okay, and how what what they expect in motions. So basically, a motion is going to have is going to cite a law. It's going to cite certain authority, and so if in your case you were forced to believe, or you just were led to believe, that child support was intended for your child, you were also led to believe that you had to do this, then the remedy is to sue. Okay, and you have to sue for breach of contract, or falsifying contracts if it's as crazy as like my case is. But there's many different things you can do if you're already in a case. If you already have gone through the judicial side of it, then you can file certain motions, but motions to dismiss if you were never served right. But those rules are in the books, people. We cannot